how company-owned insurance can leave your agency underinsured. You and your partner did the responsible thing. You bought life insurance so that if one of you dies, the agency has the cash to buy out the family and the business to survive. But here's the problem. In 2024, the Supreme Court held that the same company-owned insurance can raise the estate tax value of the business without the buyout obligation canceling it out. Two things fell out of that. The policy you thought was big enough may not be, and the deceased owner's estate can get taxed on more value than it actually received. It was a unanimous decision, 9-0. And most agency partners with a buy-sell have never heard of it. Let me show you the trap because the fix isn't complicated once you see it. So let's level the set, because a buy-sell agreement sounds like boilerplate and it's something you signed once maybe and filed away. A buy-sell is the document that decides what happens to your ownership when life happens. A partner dies, gets disabled, retires, divorces, or just wants out. It answers 3 questions. Who's allowed to buy the departing owner's share? How you put a value on that share? And where the money comes from to actually pay for it. And it's the third one that is where the story lives. Most agency owners don't have a spare 7 figures sitting in a checking account to buy out a partner's family overnight. So the agreement gets funded with life insurance. The partner dies, the policy pays out, and that money buys his shares. Clean on paper. But the Supreme Court showed us where the paper tears. There are 2 common ways to structure this, and the difference is the whole ballgame. Structure 1 is a redemption, sometimes called an entity purchase. The agency itself owns the life insurance policies on each partner. A partner dies, the company collects the money, and the company buys back the dead partner's shares. Structure 2 is a cross purchase. Here the partners personally own policies on each other. You own a policy on your partner owns one on you. A partner dies, the surviving partner collects and buys the shares personally. The company never touches the money. Most agencies I see are set up the first way, with the redemption, because it's simpler to administer. One set of policies owned by the business, and that simplicity is exactly what bit the taxpayer in this case. The case in point is called Connelly versus United States. And let me give it to you in plain English with the real numbers, because the numbers are the whole lesson. 2 brothers owned a building supply company. They set up a redemption style buy-sell, and the company bought life insurance on each of them, $3.5 million each to fund it. One brother dies. He owned about 77% of the company. The company collects the insurance and uses $3 million of it to redeem his shares from the estate. Done, but not done, because then the IRS valued the company, and here's the punchline. Once you count that insurance as a company asset, the whole business was worth about $6.9 million, which made the dead brother's 77% worth roughly $5.3 million for estate tax purposes. So look at that gap. The estate got paid $3 million. It got taxed as if the shares were worth $5.3, and that mismatch drove an extra $889,000 of estate tax. And that's the trap. The family fought it. Their argument sounded reasonable. Sure, the company got the insurance, but it owed that same money right back out to buy the shares, so it's a wash. Net zero. The Supreme Court disagreed unanimously. And here's the court's actual reasoning, because the shorthand version gets it wrong. The court did not say that the company loses nothing. The company is worth less after it pays out the redemption, but it also has fewer shares outstanding. In a fair market value redemption, the assets leaving the company and the shares being canceled are supposed to have an equal value. So the obligation to redeem by itself doesn't cancel out the insurance proceeds when you value the shares in the moment right before the buyout. Notice what the court didn't say. It didn't say a redemption obligation can never reduce a company's value. It left the door open for cases where an obligation forces a company to say, liquidate the operating assets and damage the future earnings. The narrow holding is this: in a redemption funded with company-owned insurance, a fair market value redemption obligation generally does not offset the death proceeds just because the proceeds are earmarked for the buyout. And here's the takeaway. I want you to carry out the Connelly numbers, and it's not one you'll see in the scary headline. Don't ask only whether your buy-sell is funded with insurance. Ask whether that insurance amount will still be enough to buy the shares at their rare value after the proceeds themselves get counted in valuing the company. Because in Connelly, the $3.5 million policy looked plenty big until the payout pushed the company's value up, and suddenly the shares were worth more than the money set aside to buy them. The court itself basically acknowledged the company would have needed a lot more insurance to redeem those shares at fair value. And that's the underinsurance trap. The policy that looks right on the day you sign can be short on the day it's needed. Now let me be straight with you here, because I'm not here to scare you into something. The estate tax part of this only bites if the estate is big enough to owe estate tax at all. In 2026, the federal basic exclusion is about $15 million per person. So a married couple can potentially shelter around $30 million by using both spouses' exclusion, but that's not automatic. It can take planning and a timely portability election to preserve the first spouse's unused amount. You may hear people talk about that exclusion of $15 million as permanent, but the honest version is there's no scheduled sunset under the current law. Congress can always change it, so plan on the number you've got, not the number you've been promised. If your total estate is comfortably under that, the estate tax headline in Connelly may not hit you directly, but don't tune out. Two reasons. One is a growing agency plus a big life insurance policy, plus a building, plus your home, plus your retirement accounts adds up faster than owner's thing. And at the insured owner's death, proceeds payable to the company can increase the value of the company and therefore the value of that owner's shares. People who were sure they'd never have an estate tax problem may get surprised. And two, this applies to every partnered agency regardless of size. Connelly is really a lesson about funding and valuation. Whether or not you ever owe a dime of estate tax, the underinsurance problem is the same. If the buyout price can climb above the money set aside to fund it, someone is going to come up short. The estate, the surviving owner, the family, and that happens at every size. All right, before you go, if you're an agency owner and you want to keep more of what you make, I've got two things for you. First, grab a copy of my book, The 12 Biggest Tax Mistakes That Cost Agency Owners Thousands. It breaks down the exact mistakes I see every day and how to avoid them. Second, if you want to see what this looks like for your business, get a free tax analysis. We'll take a look at what you're doing now and show you where you might be overpaying. And if this video helped you, make sure you subscribe so you don't miss future strategies on tax planning, cash flow, and building a more profitable agency. I'll see you in the next video.